Welcome to Protecting Your Legacy with Estate Planning.
Hey everybody, welcome back to an all-new episode of Protecting Your Legacy with Estate Planning with Adam Grant. I'm your host, Mike Leon. Adam here is the founding partner of Stonewood Law out in Encino, California. He's got over a decade of legal experience focused on estate planning, probate, conservatorships, supplemental needs trusts, and entertainment law. Known for his client-centered approach, Adam's been helping Southern California families protect what matters most and build lasting peace of mind for generations to come. And in today's episode, we're going to be talking about healthcare directives and powers of attorney, two essential tools that every family should understand. So, Adam, good to see you as always. Can you start by explaining to the audience what is a healthcare directive and why is it so important?
Yeah, absolutely. Mike, thank you again for having me. And these are very important instruments. We want to talk about why powers of attorney are so essential. It comes with an advanced healthcare directive if you do this with an attorney more often than not, and a HIPAA release. What those documents are, we do a lot of planning for what happens when you pass away, but there's also the planning of what happens when you're here and you can't make decisions. A lot of people assume that their spouse or their child or their mother can check in on their medical plan, their medical records, their doctor, make decisions for them, sign their name on their taxes. That's just not the case. To sign on someone else's behalf, you have to have an official power of attorney, durable power of attorney, an advanced healthcare directive for medical, and a HIPAA release accompanies that or goes with it so that we can ensure they get the medical records, information that's needed to take to the next doctor if that's how they decide to handle the client.
So, Adam, what does a power of attorney actually cover? And is it different from the healthcare directive?
Yes. So great question. They're two different documents. I like to ensure that both of them come together so that they're covered on both the medical and the financial side. The durable power of attorney, that's for financial matters. That's where you're going to stand in and make decisions, whether it's related to their financial affairs, how their taxes get paid, if they take loans, if they can sell their home. There's a lot of things that you can elect through this durable power of attorney. When it's done with an attorney, someone like myself, I will walk you through those designations. And in those designations, you get to decide or restrict the powers of the agent. And you can have one agent, you can have two agents working together. They can have separate independent powers, or they can work together and act by majority. You can have subsequent agents, but these agents are then equipped and have the power to take the medical powers into their hands, make decisions when you're in the hospital and you can't do that for yourself, and make financial decisions through the power of attorney.
Adam, I believe in a previous episode, we talked about the importance of doing these documents early on and kind of dispelling that. What point in a person's life should they do this? This is not only for seniors, right? Younger adults need them as well?
That's such a great question. So I encourage all my clients to do this anytime they have a child or a grandchild over the age of 18. So that's pretty much anyone in the United States. What you get to do is you choose through this instrument when it becomes effective, whether that's upon the person's incapacity or if it's immediate, right after signing. And that essentially gives the person that authority right off the bat to make these decisions, to go into the hospital and say, no, this is not the right doctor, or to pay your taxes and go to a bank and say, I have power of attorney. This person is incapacitated. Sorry, you can see this letter from the physician, and we need to have control over those assets so we can take care of the client.
What happens if someone doesn't have these documentations and they are incapacitated? What happens then, Adam?
Yeah, so that's really the tough part of estate planning and probate law. Clients will often find themselves on the other end of this, where they've already lost their capacity. And when you don't have capacity, you cannot then execute these agreements, which is a big problem. So you're beyond the point of electing someone to make these decisions, and you no longer can make these decisions for yourself. In that case, you typically have to go the route of a conservatorship. Those are a very long, lengthy process here in Los Angeles, at least. And they're costly. It takes time and money, and you don't want to have to go that route. With a simple planning of ahead, you get this instrument in place, you have these documents ready to be presented to whatever authority is needed at that time, and then you don't have to do the cleanup. You don't have to seek a conservatorship. You don't have to pay the tens of thousands of dollars and wait all that time because you have the agency and the authority to make these decisions.
Let's expand on that a little bit more because I know there's guardianships and conservatorships. So explain a little bit more of how these documents help the families avoid court involvement.
That's right. So guardianships are for anyone who's under the age of 18. A conservatorship is for someone who's in the need and over the age of 18. These two documents, there's a guardianship and conservatorship. The guardianship is for anyone under the age of 18. A conservatorship is for someone in the need and over the age of 18. Now, you want to get ahead of planning, so these documents are essential. If you have a conservator granted by a nomination of conservatorship, the court can easily appoint a conservator for you. Absent that, there's a lot of petitioning and argument to be made, and perhaps someone else comes in and objects to that. The guardianship, of course, for someone under the age of 18, perhaps their parents aren't available and they need someone to stand in. But these documents, to the extent, of course, they have capacity and can then make their agent designation, they will have this in place and don't have to do the cleanup afterward.
What kind of, I want to go back to the healthcare directive for a second. What kind of decisions can a healthcare directive address? Is it medical treatment, end of life care?
Yeah, so when I do this with clients, there's elections to be made both on the durable power of attorney and in the HIPAA release. The durable power of attorney, you're restricting if you want their agency to make transactions on your real property, pay your taxes, etc. On the healthcare side, you'll make really important elections, certain things you probably haven't discussed or thought about in some time. Your preference to be buried or cremated, your preference to have your body parts or your organs donated to science, education. You have a lot of elections you can make, and we walk you through each of these and what they mean. You can also customize your direction. So if you don't want to be admitted to a psych ward, you can put those instructions in there. And this helps guide your agent with your wishes and your intent so they can carry that out when it comes time, if it's ever needed.
Let's go back to the durable power of attorney for a second. So for finances, what powers can an agent have under that? And how does it truly protect someone's assets?
Yes, so with the durable power of attorney, typically we'll have clients come in and make their elections in person. Same thing with the HIPAA release and advanced healthcare directive. You can customize what agency you give to these agents. You can restrict their powers if you want to restrict their ability to pay your taxes or adjust your mortgage or take loans out on the estate. You can restrict these powers, but you will go through this document with me if you were doing this one-on-one and essentially give guidance to your agent, whether you want to have them have full agency and do any and everything as it relates to your estate, or if you want to restrict those powers.
Adam, can you, and I know you said this a moment ago, but can you share an example where somebody had these documents in place and it made a potentially tough situation easier for the family, and then the reverse of where they didn't have them and it created hardship for the family?
Yeah, so I've noticed with families that do have this in place, things do go very smoothly. They can administer the estate. Sometimes there's a hiccup with the bank, but essentially they can get the bank to cooperate, release funds or give access to funds so they can better take care of this person. It's the other side of things that really hurts. And you see clients often who don't have these powers of attorney, advanced healthcare directives in place, and then they're trying to play cleanup, which is what happens more often than not. In those cases, you do have to seek a conservatorship, and that is a long, arduous process. It's timely and costly. It can be avoided and should be avoided. And anyone over the age of 18 should take use of these instruments. They're out there. They're simple. There's not a lot to them. I mean, really, they shouldn't be very expensive if you want to do these on their own. That said, they're very important, and what they'll save you on the back end is invaluable. The conservatorship process should be avoided. It doesn't need to happen. And if you have these documents in place, it's a relatively smooth process.
Invaluable. It leads to my next question as we land the plane on this episode. Tell somebody out there who's listening to this right now, they haven't done this yet. They haven't set up any of this. What's the first step you would advise them in terms of getting this healthcare directive and the power of attorney in place?
Yeah, so anyone over the age of 18 who does not have this, I would strongly consider just reaching out to an attorney or finding out how to do this on your own. They're not very complicated and they are very important. They're worth their weight in gold. And of course, what you'll want to do is think in advance of who you'd want to be your agent. Perhaps you have two agents or you have a team of agents and then a subsequent agent after them. And how much agency you want to give them. Do you want to give them a blanket authority to do any and everything as it relates to your financial affairs, your estate, and your medical affairs? Or do you want to restrict those authorities? And you can do that with the attorney when you go through the document, essentially electing which powers, if any, to give to these agents.
Yeah. Adam, thank you for the time and insights on this. We truly appreciate it as always.
Thank you for having me.
And thank you to everybody out there listening to today's episode of Protecting Your Legacy with Estate Planning. If you'd like to learn more about setting up your healthcare directive or your power of attorney, do me a favor, visit stonewoodlaw.com today. Don't forget to like, subscribe, leave us a comment, or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.